Mr. Stephen Coxford, Vice-Chancellor, Dean Holloway, distinguished guests, students, thank you all for coming. I'd like first to thank once again Stephen Coxford for generously enabling the law school to host this series of lectures. Also to thank Grant for doing me the great honour of inviting me to give the third in the series. Everyone here, but especially me, must be hoping that an hour from now he doesn't regret it. This is my third visit here, and I always enjoy the beautiful campus and collaborating with the public law team here. But now down to business. Early this year, the High Court of Australia, in a case called Kirk, made a radical change to our constitutional arrangements. It held that state parliaments could not validly enact a privative or ouster clause, preventing a state Supreme Court from reviewing decisions of inferior courts or administrators for jurisdictional error. The case involved an apparent injustice to an individual that the courts would have been unable to remedy had the privative clause been effective. Now, until this decision, it had been universally assumed that state parliaments could validly enact privative clauses, and in many previous cases, courts considered how to interpret them without ever suggesting that they might be invalid. Now, the court's reasoning in Kirk on this point is quite brief, indeed perfunctory, and it's widely regarded as quite implausible. The court purported to rely on originalist reasoning. It fixed on a constitutional provision that provides for appeals from state Supreme Courts to the High Court. And it reasoned that in 1900, when the Constitution was enacted, it was an essential characteristic of the very concept of a state Supreme Court that it had jurisdiction to review administrative decisions and correct jurisdictional errors. So, on this view, any law removing or restricting that jurisdiction would be inconsistent with the very meaning of the words Supreme Court in the Constitution. Now, this is regarded as implausible because no one had ever before adverted to this supposed conceptual truth, not in or around 1900 and not subsequently, even though numerous privative clauses had been enacted and judicially interpreted. So in this case of Kirk, the High Court asks us to believe that all these privative clauses all along were inconsistent with a concept central to the constitutional thought of lawyers and judges in the year 1900, even though none of them had noticed it. The court is implicitly claiming that 120 years later, it's arrived at a more accurate understanding of their concepts than they themselves possessed. Now, judges and lawyers disapprove of privative clauses because they believe that the rule of law requires that every power possessed by government officials must be subject to legal limits and that those limits must be enforceable by an independent judiciary. And privative clauses offend that idea. On the other hand, within Britain itself, the doctrine of parliamentary sovereignty allowed Parliament to enact privative clauses to exclude judicial review, and the constitutions of British colonies conferred a similar plenary power on them. The perceived conflict between the principles of the rule of law and of legislative sovereignty was resolved by judges interpreting privative clauses as narrowly as they possibly could, and sometimes interpreting them almost out of existence, and I'll come back to that. The decision in Kirk escalates judicial resistance to privative clauses to a new level by declaring them at the state level to be, for the most part, constitutionally invalid. It makes redundant the previous strategy of interpretive ingenuity. The decision has been praised, perhaps rightly, for strengthening the rule of law. But what if the decision involved, as I'm suggesting, a deliberate change to the Constitution, rather flimsily disguised as an interpretation of it? The High Court could then be charged with having violated Section 128 of the Constitution, which says that the Constitution can only be changed by Parliament with the assent of the electorate in a referendum. As a former Chief Justice said, it's the duty of the court not to interfere unless the Constitution requires it to. Otherwise, the Chief Justice said, the interference of the court is an unwarrantable intrusion and a breach of law as great as any it assumes to correct. Now, if a court violates the law, it breaches the rule of law. And this includes changing laws that it has no authority to change. Yet, its decision might advance the cause of justice or good government, or it might strengthen the rule of law in other respects or overall. And this apparent paradox is the topic of my talk. Now, some of you might find it grating or even offensive to hear talk about judges violating the law and concealing the violation with an untruth. But I ask you to bear with me, I have to use this terminology. I'm going to talk, brace yourselves, I'm going to talk about noble lies, fig leaves, wishful thinking, and sloppy thinking. Now, I find this just as unsettling as anyone else because I myself incline towards a fairly strict legalism. This is something I said in print 10 years ago, quote, modern judges are prone to solemnly invoke the rule of law to justify inventing limits to the authority of other government institutions. They should reflect on the fact that they too are subject to the rule of law, and that ultimately the only practical mechanism for ensuring that they abide by it is their own scrupulous intellectual honesty. If that cannot be trusted, the rule of law is in peril. Now, in this lecture, I want to question my own inclinations and ask whether judges might sometimes be morally justified in engaging in covert law breaking, whether some measure of judicial subterfuge might be desirable because it enhances justice, the rule of law, or good governance. There's a plausible argument that it might be justified, and also that judges engage in subterfuge more often than perhaps we like to think. My attempt to explore these issues is absolutely not an attempt at judge bashing, and if there are any judges present, I sincerely hope that you don't construe it in that way. Those involved in the administration of the law aspire to happy endings, practical outcomes that promote justice and the common good. And this has produced a perennial tension in legal thought between, on the one hand, fidelity to legal norms and their logical implications, and on the other hand, the entirely understandable urge to do justice, as the judges see it, to the flesh and blood individuals who stand in front of them. And partly I'm asking how judges do and how they should resolve that tension. Now, let me clear up some possible distractions at the beginning, and this will be perhaps a little dull, but I've got to go through some qualifications. We all know that law can be to some extent indeterminate. For example, when it's ambiguous, when it's vague, inconsistent, or when it's just silent about issues that judges have to decide. Judges do have an obligation to decide cases that are properly brought before them, even if the law doesn't give them an answer. In that situation, they have to act creatively and in effect make new law, guided by political morality. I'm well aware of that, but I'm simply not concerned with that at the moment. I'm not concerned with judges filling in gaps left by indeterminate law. What I'm interested in now is judges allowing extra legal considerations to override determinate law. Now, one way, of course, that judges can do this is to pretend that determinate law is really indeterminate and that it leaves them legitimate scope for creativity. But they rarely do that because they're usually reluctant to admit that they have any lawmaking discretion at all. Professor Martin Shapiro once published an article titled "Judges as Liars," in which he argued that judges everywhere tend to attribute their decisions to pre-existing law, even when they've had to make new law because of legal indeterminacy. This is supposedly because losing parties are more likely to accept adverse decisions if they're persuaded that they were mandated by law. Shapiro concluded his article by saying, quote, "Judges necessarily lie because that's the nature of the activity they engage in." Now, others, including judges, have put the same point somewhat less provocatively. For example, former Australian High Court Justice Michael Kirby claims in a book that judges of the English tradition nearly all practice the noble lie of strict and complete legalism. His book is scattered with references to this as a noble lie, fiction, pretense, or illusionism. And he's a former High Court judge. Another big issue that I need to set aside concerns the common law. Where common law is concerned, the highest appellate court is legally permitted to override pre-existing norms if it regards them as unjust. That doesn't raise the kind of conflict or dilemma that I want to explore tonight. The dilemma I'm interested in generally concerns constitutions or statutes that judges have no authority to amend. Now, some scholars argue that judges do have legal authority to change statutes and constitutions, presumably because when they look at the historical record, they find that judges have in fact done so. A major difficulty for such arguments is that judges rarely, if ever, claim to have such authority. Even when an interpretation of a statute seems extraordinarily creative, judges purport to be merely clarifying its true meaning. I will argue that that sometimes has been a pretense. But what judges say they do is much better evidence of the scope of their lawful authority than what they might sometimes in fact do. That's because any claim about their lawful authority must surely be able to pass a test of public candour. If the claim is not and cannot be candidly asserted by judges in public, it's surely false. How can judges have a legal authority that they dare not assert publicly and feel compelled to keep concealed? Now, I also want to emphasise that in what follows, I'm not presuming the truth of some version of legal positivism, which regards law as ultimately a matter of fact and not of morality. Non-positivist theories maintain that establishing what the law is depends partly on considerations of justice as well as matters of fact. But they don't maintain that law and justice are one and the same, and that law is whatever it ought to be, regardless of facts about what norms have been enacted. That's why the leading non-positivist today, Ronald Dworkin, acknowledges that even on his view, the law might be so unjust that judges ought morally to disobey it. It's true, however, that non-positivist judges would probably encounter fewer occasions in which they experience a conflict between the demands of morality and the demands of law. Now, just another qualification. My theme may seem less relevant in jurisdictions like yours that have a bill or charter of rights that give judges much more power to avoid unjust results without having to engage in any subterfuge. But experience, especially in the United States, shows that a Bill of Rights does not remedy everything that a judge might consider unjust. Its scope is, as Grant Huscroft has usefully said, finite. And so my theme should still have some resonance here. Now, I'm going to, in a minute, give some examples of alleged judicial subterfuge, but of course it's very difficult to know whether judges have engaged in this or not, for various reasons. Firstly, of course, it's always possible that judges simply got the law wrong, perhaps as a result of muddled thinking. Secondly, it's possible for judges to engage in wishful thinking and delude themselves. All of us, when we're strongly attracted to a particular conclusion, are sorely tempted to evaluate argument and evidence selectively, to bend and stretch logic in order to get to that conclusion. Justice Cardozo said that judges who innovate tend, quote, to disguise the innovation even from themselves and to announce in all sincerity that it was all as it had been before. Now, despite these difficulties, there is quite a bit of evidence in literature in many jurisdictions that judges do occasionally engage in subterfuge. There are different kinds of subterfuge. First, there's the lie, in this case, the white lie or the noble lie, which is known to be untrue and intended to deceive. Then there's the half-truth, intended to deceive by deliberately failing to mention relevant qualifications. Next, there's what is often called the fig leaf, a falsehood that is neither intended nor likely to deceive. A fig leaf covers something distasteful or offensive. Everyone knows what's underneath, but some would be disturbed if they were directly confronted by it. The fig leaf somehow preserves the decencies without actually fooling anyone. Some statements, like euphemisms, mask uncomfortable truths, whose blunt statement would be discourteous or hurtful or disturbing. Note that something can function both as a fig leaf for those in the know, perhaps lawyers, and also as a noble lie that deceives more naive or ignorant people, perhaps politicians or the general public. And perhaps that's an example of what is sometimes called doublespeak. Now, I don't know whether you're sitting there completely shocked that I'm saying these things, but lawyers do sometimes suspect judges of subterfuge. Lawyers often employ euphemisms. For example, they say that a judge adopted a strained interpretation of a provision, when what they really mean is that the judge gave it a meaning it clearly did not possess. Or sometimes they're more blunt. They speak of judicial acrobatics, contortions, tortured constructions, and so forth. Over a century ago now, Roscoe Pound, who became Dean of Harvard Law School, wrote an entire article in the Harvard Law Review titled Spurious Interpretation, which he described as, quote, putting a meaning into the text as a juggler puts coins or whatnot into a dummy's hair, to be pulled forth presently with an air of discovery. Legal historian Edward G. White once referred to, quote, the conventional techniques of judicial subterfuge. Now, no doubt some, perhaps many allegations of subterfuge have been erroneous, but it's very unlikely that they've all been. But let me emphasise that the phenomenon I'm concerned with makes up a tiny proportion of the cases that judges decide. I'm certainly not alleging that judges are going around telling lies all the time, or most of the time, or even a lot of the time. But now let's look at some examples. It would be very easy to start with American law because there's a long tradition in that country of sceptical theories, maintaining that judges concoct legal rationalisations for results that they've decided in advance. And there are commentators who have claimed that this is common in the United States. I doubt that, but I thought I'd make my job more difficult by starting somewhere else, with the birthplace of the common law, Britain. Now, although the British legal tradition is today regarded as much more formalistic than the American one, it does have a pragmatic strand that includes judicial subterfuge. After all, the medieval common law invented many so-called legal fictions. These fictions were used by courts to get around rigid procedures and forms or to extend their jurisdictions in ways that were not authorised by pre-existing law. For example, the jurisdiction of exchequer was confined to the enforcement of obligations owed to the Crown. But the court allowed plaintiffs to pursue ordinary debts by pleading that they owed money to the Crown, but they couldn't pay because their creditor had not paid them. After a time, this became a standard form of pleading, and everyone knew it was a fiction. So then it was a fig leaf rather than a lie used to conceal the truth. Professor Lon Fuller published a whole book about legal fictions and said that they could be found in almost every area of law. They provoked diverse reactions. Jeremy Bentham, for example, denounced them as willful falsehoods and swindles aimed at the stealing of legislative power. On the other hand, Sir William Blackstone said that the end of facilitating cautious legal change justified the means, which involved the use of falsehood. Professor Albert Venn Dicey, very famous in British constitutional law, once said that fictions had helped the common law to subordinate the so-called absolute prerogatives of the Crown, which kings like James I and Charles I said were beyond legal scrutiny. This is now regarded as a foundational victory for the rule of law, that is to say, the subordination of these absolute prerogatives to the common law. But this is what Dicey said, quote, "The fictions of the courts have in the hands of lawyers such as Coke," he means Sir Edward Coke, legendary Chief Justice of King's Bench and Common Pleas. So the fictions of the courts in the hands of such lawyers served the cause both of justice and of freedom, and served it when it could have been defended by no other weapons. Nothing could be more pedantic, nothing more artificial, nothing more unhistorical than the reasoning by which Coke induced or compelled James I to forego the attempt to withdraw cases from the courts for His Majesty's personal determination. But no achievement of sound argument or stroke of enlightened statesmanship ever established a rule more essential to the very existence of the Constitution than the principle enforced by the obstinacy and the fallacies of the great Chief Justice. Now, British judges, in fact judges generally, have found ways to evade laws that mandate punishments they regard as excessive. One of the ancient legal fictions involved benefit of clergy, whereby clerics accused of crimes could only be tried in church courts and not in common law courts. Common law judges used this device to evade a law requiring felons to be sentenced to death. They held that anyone who could read a psalm was deemed to be a cleric. They then extended this to illiterates who could recite a psalm. In his History of English Criminal Law, Radzinovich observes that the proliferation of statutes imposing capital punishment in the late 18th century, which was opposed by an advanced section of public opinion, led to judges often evading them by distorting or misapplying principles of statutory interpretation. The judges invented a series of technicalities that were clearly outside the contemplation of the legislature, I'm quoting here, and sometimes directly opposed to the known legislative intent. Judicial evasion remains today a common response to harsh or mandatory sentencing laws, and we find that in Australia and the United States. Turning to contract law, a learned author says that courts have used a great variety of techniques to pay lip service to contract law in theory while ignoring it in practice. These techniques, that he calls non-interpretation, have been used to make contracts read more fairly from the court's point of view. For example, manipulating the concept of fundamental breach so that exclusion clauses would not gravely disadvantage weaker parties, finding collateral contracts that introduce different terms from the main contract, limiting the scope of contracts through other devices in order to bypass undesirable terms. The author concludes, any but the most biased and blind observer can appreciate the policy considerations lying behind the manipulations of the various techniques. Conor Gearty, Professor of Human Rights Law at the London School of Economics, refers in a recent book to what he calls the seduction of the well-crafted lie. And he observes that generations of judges, I'm quoting here, generations of judges have found themselves embracing various kinds of deception as an essential way of bridging the gap between law and justice. He discusses a number of myths and fictions whose lubricating power, he says, has enabled justice to be done in the teeth of uncompromising facts or logic. For example, he discusses, quote, a tempting fiction drawn from the human rights field, namely the notion of an assumed waiver of a right in a situation where the factual evidence for the breach of the right cannot be gainsaid, but where insistence on it would carry a range of inconvenient social costs. The now traditional judicial resistance to privative clauses that I mentioned at the beginning has involved widely acknowledged subterfuge. Many critics have claimed that in the most famous British case on this, the Anna's Minute case, the House of Lords in effect used specious reasoning to circumvent Parliament's command that decisions of a statutory authority were not to be judicially reviewed. New Zealand Justice E.W. Thomas recommended that we candidly admit what judges do in such cases. Quote, "I know of no rule of law or logic which would make judicial disobedience more palatable simply because it is done covertly." Sir William Wade, eminent Cambridge professor of administrative law, referred to the logical contortions and evasions to which judges were driven by legislation aimed at reducing their powers of review. He said that the judges' actions should be condoned, not criticised. The so-called ultra vires doctrine in administrative law holds that the grounds on which judges review the decisions of the executive government are imposed by statute, implicitly if not explicitly. In other words, these grounds of review were not created by the judges themselves. But Sir John Laws, on the Court of Appeal, has described this doctrine as a fig leaf. He uses the word fig leaf, providing a facade of constitutional orthodoxy while being out of touch with reality. Lord Steyn of the House of Lords also described the ultra vires doctrine as a dispensable fiction. Now, these examples from administrative law are related to a broader category of cases involving presumptions of legislative intention. For centuries, courts have said that in interpreting statutes, they are guided by a presumption that Parliament does not intend to interfere with established common law rights, although this can be overcome by express words or necessary implication. But it's increasingly fashionable for this justification to be dismissed as an artificial rationalisation or polite fiction. It's said that the strong presumptive rules are applied even in the face of clear legislative intention to the contrary. Some say that the common law presumptions no longer have anything to do with the intent of the legislature, they are means of controlling it. Now, these people believe that the courts have been stubbornly protecting cherished common law principles from legislative interference. But if so, the judges have not been candid in deploying the presumptions in the past. They've sometimes used them as a smokescreen to conceal judicial disobedience of Parliament. And Dean Holloway here has used terms such as judicial legerdemain and curial sleight of hand to describe judges, quote, turning a Nelsonian eye to what would seem to be perfectly clear statements of legislative intent, end of quote. Some judges now dismiss the whole idea of legislative intention as a fiction. It's interesting, though, that those same judges invariably continue to find it useful, if not necessary, to use the term legislative intention when they construe statutes. Now, this may mean that they cannot avoid legislative intention because, despite their disclaimers, it does really exist. That's my own view. But if they believe it doesn't exist, are they using the rhetoric of legislative intention as a fig leaf to conceal something else, such as their own creative rewriting of statutes? Some judges actually say that the notion of legislative intention is a fiction, but a useful fiction. But what use can such a fiction have, other than to conceal the truth? Oxford scholar Nicholas Barber has provided various examples of British courts in effect amending statutes to remedy injustice while purporting to follow orthodox canons of interpretation. He talks about privative clauses. He also talks about the judges' resistance throughout the first half of the 20th century to Parliament's attempts to confer legal immunity on trade unions for losses incurred during industrial disputes. The courts found that policy of the then British Labour Party morally repugnant, and they continually introduced new forms of common law liability to frustrate Parliament's clear intention. Patrick Devlin's book, The Judge, written after he had retired from the Court of Appeal, includes a chapter titled The Judge and the Aequum et Bonum. Now, this expression, aequum et bonum, comes from a long Latin maxim that I won't bother reading out, but it's translated as a good judge decides according to justice and right and prefers equity to strict law. Here's some of what Devlin says in the chapter, quote, "Lawyers accept the distinction between justice according to law and justice on the merits, or ex aequo et bono, as they call it. We have to accept that every now and again, fortunately quite rarely, a judge is confronted with having to deliver a judgment that seems to him to contain too much law and not enough justice. When that happens, there is a temptation to alter the mixture a little. Stretching the law or moulding the facts to fit the law is the time-honoured method by which the judge, consciously or unconsciously, probably half-consciously and not permitting himself too acute an analysis, makes room for the aequum et bonum. At all judicial levels, in all judicial systems, the law is sometimes stretched, perhaps a little shamefacedly. He adds that it's a condition of the use of this and all other methods and devices having the same object, that the object should not be admitted. He asks why the courts don't frankly admit what they do in such cases. He explains that would be contrary to accepted constitutional orthodoxy, settled in the 17th century, which denies the existence of any power to dispense with the operation of a statute. Therefore, he says, the judge cannot openly dispense, but he can stealthily stretch or mould. In the 1990s, a political scientist, David Robertson, who published a book about the House of Lords, interviewed all of the then law lords. He reported that in most of these interviews, the judges spoke about cheating, reaching decisions that violate the constraints imposed by accepted canons of legal reasoning. Many of them accused Lord Denning of cheating, and some criticised their current colleagues. For example, quote, "I dissented because the majority were cheating." They described their inner sense of obligation by saying, one tries not to cheat, but they made concessions such as, perhaps I cheated a little bit in X against Y. They did indicate a strong belief that such cheating is rare, although Robertson concluded that it was rarely necessary because the indeterminacy of the laws they were dealing with gave them such extensive discretion. Now, sometimes these tensions are expressed in judgments. For example, in De Port Steeles against Sears, a famous 1970s case on statutory interpretation, Lord Diplock criticised the Court of Appeal, led by Denning, for, quote, inventing fancied ambiguities as an excuse for failing to give effect to the plain meaning of the statute, because the court considered that the consequences of doing so would be expedient or even hang on, I must have the wrong quote mangled here, because the consequences of doing so would be inexpedient or even unjust or immoral. Lord Scarman alleged that the Court of Appeals, that in the desire of the Court of Appeal to do justice, it failed to do justice according to law. Okay, so that's an overview of the tradition of pragmatism, or if you like, subterfuge in Britain. I could provide many examples from other jurisdictions, especially, as I said before, the United States. Many of them would be similar, involving, for example, statutory interpretation, involving mandatory sentencing laws and capital punishment. Judicial resistance to the rule excluding unlawfully obtained evidence has also been widely alleged. Of course, the major difference, given that Britain has no written constitution, concerns the interpretation of the constitution. Many suggested examples of judicial subterfuge in the United States, not only over the last 50 years, but well before that, involve claims that the Supreme Court willfully read its own notions of justice and human rights into the Constitution. The critics of judicial activism, as it's called, have not always been motivated by political opposition to the results. Some of the critics have been liberals who would have endorsed the result from a political perspective, but nevertheless expressed shock at the court's poor reasoning. Court of Appeals Judge Richard Posner refers to, quote, the considerable disingenuousness of many of the judicial opinions that are most admired, such as Brown v Board of Education. If utter candour is a duty of judges, as of no other public officials, and if disingenuous judicial opinions are illegitimate, we've had a crisis of judicial legitimacy since Marbury and Madison. Now, of course, as I said earlier, some of these claims may be exaggerated, may be false, but it's doubtful that all of them are. I want to emphasise, though, that many examples, like the Kirk case in Australia that I started with, involve judges bolstering their own independence and authority to review the activities of the political branches of government. In other words, many of these examples involve judges using subterfuge to protect what they believe to be essential to preserving the rule of law. It's widely believed that Chief Justice John Marshall lied in the famous case of Marbury and Madison. That's the foundational case of constitutional judicial review in the United States. It's not said that Marshall lied about the doctrine of judicial review. Rather, the claim is that he lied about the meaning of a statute, that he adopted an absurd interpretation of the statute in order to raise the question of judicial review. Yet most commentators acknowledge that the judgment was a masterpiece of shrewd political statesmanship, which justifies its reputation for greatness. The decision of the Supreme Court in Bush v Gore, which put a stop to a voting recount in Florida and made George W. Bush president, was subjected to savage criticism from leading scholars who alleged intellectual dishonesty on the part of the Republican-appointed majority judges. According to some, this was for an ignoble rather than a noble cause involving blatant political partisanship. But other critics were more generous. For example, one said that arguably the court deliberately acted in a way that could not be legally justified in order to prevent greater harms. What were these possible greater harms? Well, firstly, preventing a dangerously destabilising constitutional crisis spiralling out of control. Secondly, preventing the Democrat-dominated Florida Supreme Court from manipulating the law to help Al Gore win the election. Now note that both of these objectives relate to preserving the rule of law. In the latter case, the higher court violates the law in order to prevent a lower court from doing so. Turning to Australia, the most blatantly inventive decisions have been designed to bolster judicial authority or judicial independence. Australian judges have used exactly the same tactics as their British counterparts to evade privative clauses. Their use of, or pretended use, of orthodox interpretive techniques has been described by leading commentators as an exercise in sophistry, as disingenuous disobedience of the will of Parliament. In constitutional law, the High Court first began to construct a doctrine of strict separation of judicial power in a case where it was contrary both to the constitutional text and clear evidence of the framers' intentions. More recently, the court partially extended that doctrine to state courts, although this was inconsistent both with previous authority and with strong disapproval expressed in previous cases of freestanding, unexpressed principles enforced independently of the text of the Constitution. Now, this was in a case called Cable, whose reasoning the late Professor George Winterton, a universally respected authority, described as, quote, barely even plausible. And the latest step is the even more radical innovation in Kirk, the case on privative clauses that I started with. Canadian courts haven't been immune to allegations of result-oriented judicial subterfuge. I won't bring up too many more examples, but in rule of law cases, the Privy Council, before 1949 and later the Supreme Court, struck down laws granting judicial power to administrative tribunals, although according to Professor Peter Hogg, your leading constitutional authority, the basis for the decisions was unclear or implausible. In 1997, again according to Hogg, the Supreme Court invoked an unwritten principle of the independence of provincial judges and proceeded to construct what he calls an elaborate edifice of doctrine with virtually no basis in the constitutional text. Let me finish with an example from India. The Indian Supreme Court famously interpreted a provision of its constitution that required the President to consult with the Chief Justice before appointing new justices to the court, as requiring that the Chief Justice's advice must be followed by the President. The court then added a requirement with no textual basis whatsoever that the Chief Justice must consult with his foremost senior colleagues before tendering that advice. Now, the court wanted to prevent itself being stacked for political purposes, but it didn't want to give the Chief Justice too much power. Both worthy goals, but the provision plainly did not mean what the court said it meant, whether the word consult is understood in its ordinary sense or in the historical context of its enactment. Now, let me turn from these examples to some reflections on them. Now, first of all, I want to ask, is there an alternative to subterfuge that can achieve the same results? Seinfeld fans will remember an episode in which George, who's reputedly an expert liar, is asked to coach Jerry in the art of lying. And George says, "Remember, Jerry, it's not a lie if you believe it." Now, judges must lie about the law only if they know that rigorous argument has shown that their preferred decision isn't logically open. But if rigorous argument is not pursued, if concepts are left conveniently fuzzy, inferences sufficiently loose and slippery, then judges can reach a pragmatically desirable conclusion with a clear conscience. And that may be why Lord Devlin said that the time-honoured method by which a judge can do justice is to stretch the law, although probably half-consciously and not permitting himself too acute an analysis. This was described by another English judge as, quote, well-meaning sloppiness of thought. Now, I doubt that well-meaning sloppy thinking can form a category independent of others that I've already mentioned. If such thinking is really sincere, with no intent to deceive, then it's an example of what I called earlier wishful thinking. If it's insincere and intended to deceive, then it's a kind of subterfuge. A conscious choice not to pursue, to the usual degree, empirical and logical analysis is a kind of intellectual dishonesty. Although perhaps dishonesty can be negligent or reckless as well as intentional. To the extent that subterfuge is involved, we therefore have to consider arguments for and against intellectual honesty in judicial reasoning. Now, almost everyone agrees that lying may sometimes be morally justified. There are a number of philosophical books devoted to this subject. At the very least, if violence is sometimes justified to protect life or freedom, as all but pacifists accept, then surely lying must also be occasionally justified. Legal philosophers often have said that in some circumstances judges might be morally justified in lying about the law. That's a standard response of legal positivists to natural law critiques. When natural lawyers accuse positivists of requiring judges to apply evil laws, the positivists reply that a judge's legal obligation to apply the law might be outweighed by a moral obligation not to. Judges should not willingly collude in extreme injustice, even if they must lie to avoid it. As the title of a recent American discussion of this phenomenon put it, to do a great right, do a little wrong. In countries where injustice, oppression, corruption are prevalent, the judicial noble lie might be justified more often. That's why the debate between natural lawyers and legal positivists has focused on the predicament of judges in regimes such as Nazi Germany, apartheid South Africa, or American states affected by slavery before the Civil War. Also, in a country where democracy, the rule of law, or a new constitution is not yet firmly established, judges might have to take more liberties in order to ensure that these institutions take firm root. Robert Bork offers this by way of justification for Chief Justice John Marshall's alleged sleight of hand in Marbury and Madison, and of the extraordinary decisions of the Indian Supreme Court might be justified on this basis. If there was a real danger of politicians stacking the bench with cronies or hacks in order to bend the law to their will, then the Supreme Court may have been morally justified in holding, contrary to law, that the requirement that the President consult with the Chief Justice meant that he had to obey the Chief Justice in appointing new judges to the court. Now, if we accept, as I think we must, that there is no absolute moral prohibition of judicial subterfuge, that it can be, at least in some circumstances, be morally justified, then it becomes a question of degree. How often is it justified in modern Western democracies? There's a growing body of literature in the American law journals devoted to the topic of judicial candour, discussing whether or not judges should always be completely frank in setting out the reasons that actually motivated them to reach their decisions. The authors usually recommend candour, except in extreme cases. But in a just published book titled The Limits of Legalism, The Ethics of Lawless Judging, the philosopher Jeffrey Ballard advocates that judges resort more frequently to furtive deviations from the law to avoid not only extreme injustice, but also moderate injustice. His book presents an unorthodox defence of judicial activism. Most defenders insist that decisions attacked as activist are legally respectable, and they dismiss the opposite view of critics as politically motivated. But Ballard is prepared to defend such decisions even if they are, as he puts it, lawless. Although he does insist that judges must be strategic, they cannot engage in this practice too often or too blatantly. Now, I haven't had time yet to read the whole of that book, but I strongly incline to the view that covert judicial law-breaking should only be resorted to in very extreme cases. I don't have any particularly original arguments for that notion, but the standard ones might go something like this. An essential function of law, often called the settlement function, is to provide a generally accepted, authoritative method of settling disputes that would otherwise be intractable. These include disputes about morality. We often have disagreements about what is morally right or wrong, and these disagreements, the evidence shows, are often never capable of being resolved. We just continue to disagree. But we need as a community to make collective decisions about these contested issues. So we need decision-making procedures whose outcomes will be accepted as binding, even by those people who continue to disagree about their merits. If the decision-making procedures are democratic, so much the better, because they provide the fairest method of decision-making. And that reinforces the obligation to respect the outcomes. If those outcomes are not generally respected, if those who disagree with them on the merits refuse to comply with them, then we remain where we started, in a predicament of perpetual disagreement and potential, if not actual, conflict. The role of judges is to make sure that these outcomes are enforced, even if they disagree with the merits. If judges didn't generally do this, they'd set a dangerous example to the rest of the community, including the other branches of government. If judges aren't prepared to obey decisions they disagree with, why should anyone else? Attempts by the judges to conceal disobedience by subterfuge are likely to fail. Their published reasoning is very carefully scrutinised by lawyers, academics and other officials. The calculations that judges would need to make if they followed Brand-Ballard's recommendations and had to assess the likely consequences of more frequent and strategic subterfuge are too difficult to be practicable. And would we really want judges to be making such calculations behind closed doors, asking themselves just how much subterfuge they can get away with? Lying violates the trust that is essential to harmonious social intercourse, and its exposure is likely to breed cynicism and loss of respect for the judiciary. Judges, as honest people, are also likely to or may suffer some psychological damage. Moreover, the historical record shows that there is no guarantee that judicial value judgments are any more reliable than anyone else's. So the supposed benefit of enhancing justice or the rule of law might not eventuate anyway. On the other hand, and there is always another hand, if judicial subterfuge is confined to remedying obvious and extreme cases of injustice or breaches of the rule of law, its exposure might not damage trust in the judiciary or breed cynicism. Indeed, knowledge that judges occasionally act in this way might strengthen public confidence in them. Going back to Patrick Devlin's book, The Judge, he says, quote, "The judicial qualities which the public singles out for praise are common sense and humanity. Devotion to the law is less admired than a willingness to strain it." And perhaps he's right. Now, let me conclude with some observations about the role of scholars and teachers of law. If in a rare case a judicial untruth is justified because of its beneficial consequences, is it the duty of scholars and teachers not to expose the lie? Perhaps even to aid and abet the lie by adding whatever authority they have as scholars learned in the law to prevent it being exposed as a lie. Let's say, for example, that I was an academic in India at the time, and I accepted that the danger of politicians stacking the bench for nefarious purposes was sufficient to justify the Supreme Court's noble lie about the constitutional requirements for judicial appointment. Presumably, I would regard myself as bound not to expose the lie. Why not, if the judges were morally justified in the first place? But if I were prepared to do that, would I surrender my right to object to other decisions on the sole ground that they were not legally justified? Would my disagreements with judicial reasoning then always depend, partly, on whether or not I like the results, and not just on whether I agree with the legal reasoning? Would I always have to address the moral and political merits of a decision, as well as the legal merits? If so, legal scholarship would become much messier and more difficult. Instead of just debating about what the law requires in some case, which can be difficult enough, it would always be necessary, in addition, to debate whether the law should be followed. Law would lose its settlement function for scholars as well as everyone else. Legal reasoning would never settle anything, and we would always have to fall back on moral and political argument. Now, actually, I don't think this would follow provided that it's reasonable to adopt a general working assumption that judges should strictly adhere to the law, an assumption that can be overridden only in obvious cases of fairly extreme injustice. Provided that assumption's made, legal reasoning and legal debate can proceed as usual on the basis of certain basic legal norms, without those norms then having to be questioned every time. Now, let me just finish with some other worries about the role of the legal scholar. The usual role of the scholar in any university discipline is to shine the light of reason and truth on the field of study in question. It's to think as deeply, rigorously, clearly and consistently as possible, and to remove confusion and obfuscation from thought. Many legal scholars see their mission in that light, and they demand the same from judges. The famous Yale constitutional scholar Alexander Bickel once said, quote, "The explication of legal principle is disciplined, imposing standards of analytical candour, rigour, clarity. The task is to reason, not to feel, to explain and justify principles to the last possible rational decimal point." In law, as in other disciplines, depth, rigour, clarity, consistency have the effect of channeling and constraining reasoning. They reduce or eliminate indeterminacies, and they close off options that might otherwise appear to be open. As logic is pursued more thoroughly and deeply, the scope for legitimate judicial discretion shrinks. But is this necessarily a good thing? Can logic be pressed too far? One of the differences between scientific and legal thinking is that in the sciences, thinking that is logically flawed or factually inaccurate will usually fail the test of practical implementation with possibly disastrous consequences. Whereas thinking that purports to elucidate existing law can be logically flawed or inaccurate and yet have beneficial consequences when put into practice. Law is often said to be a matter of practical wisdom rather than cold intellectual analysis. Does practical wisdom sometimes teach us to rein in our pursuit of logic, to blunt the cutting edge of analysis, so that we can reach or allow other people to reach decisions that from a logical point of view might not withstand too close a scrutiny? The patron saint of pragmatism in American legal theory, Oliver Wendell Holmes Jr., famously said, "The life of the law has not been logic, it has been experience." The felt necessities of the time, the prevalent moral and political theories, intuitions of public policy, avowed or unconscious, have had a great deal more to do than logical syllogism in determining the rules by which men should be governed. Holmes was talking about the common law, with respect to which that aphorism is now uncontroversial. But I'm asking whether it can be generalised to apply to statute law and constitutional law as well. But this must put legal scholars in an awkward position. How can we know when to pull our punches, when to tone down logical rigour, clarity, depth and consistency in the interests of pragmatic or just legal evolution? Logic can't be thrown out of the window altogether. We surely want judges to be constrained by law to a large extent. It would not be pragmatically desirable if judges felt free to decide legal disputes however they think best, regardless of legal norms. Is a compromise required? Is the best way to achieve that compromise to leave legal reasoning to busy practical people, barristers and judges, who have enough time to be guided by logic to some extent, but not so much time that they end up being constrained by an excess of logic, unduly tying the judge's hands? If so, then perhaps harping academics like me are just an impediment to progressive legal evolution. Perhaps everyone would be better off if we shut up and let busy practitioners get on with the practical job of lawyering. Now, I don't actually believe that, because otherwise I've wasted the last 30 years of my life, arguably. But here's a way out for me. Even if judges should sometimes subordinate legal logic to other values, logic remains an essential part of the mix. And it's needed to ensure that judges don't stray too far or too often. So the scholar committed to logical rigour can still play an important role in the system. Justice Scalia once called himself a faint-hearted originalist, and perhaps I'm evolving into a faint-hearted legalist. Thank you.